Hello, everybody. It's great to be back with you. If you're on the East Coast, it's a little bit after 12 noon. I'm here on the East Coast in New York City. I'm looking out at a beautiful day here in Midtown Manhattan. Tough to believe that we're on the other side of Memorial Day and the other unofficial, start of summer. I'm hopeful that all of you both enjoyed the extra day and as well took the time to remember those we've lost and who've served. We have a very full program, and so I won't take too much more of your time in introduction other than to walk through the agenda. So if Kathy, you would please go to the next slide, I'll let everybody know what it is we intend to cover. Thank you. And so we will have Caroline Westover back on the program. Caroline is, of course, out of our Syracuse office, focuses in employment and immigration, and there's new federal activity concerning F1 student status, which is really important for a variety of reasons, and we'll hear just why in a moment from Caroline. Jen Swartzot is with us from our Rochester office. Jen has been on the program many times over as well, and there's an interesting piece of language that came through the budget that, as all of you know, if you've been watching this program, was finalized earlier this month. And this concerns the notion of substantial equivalency within education law. And so stay tuned for that. Thereafter, Eric O'Brien and Ryan Cross, both litigators with our firm, will be providing some background and best practices when it comes to litigation strategy. And we very much look forward to having their presentation. Eric is back on the program. Ryan's actually new to the program. So you'll all have a chance to see Eric again and to meet Ryan. And then I will try to close things out by around 12:30, 30 minutes from now. So Kathy, if you go to the next slide, please, let me just provide a little bit of context. Normally, I would have a fuller presentation on the budget, but this is really what everybody in New York State should be worrying about. And when I say budget, I mean, the one that we just finally put to bed in New York State and sort of the emanations. We all know that what happens at the federal level could be, highly informative to what we'll see in New York State this summer. There are now indications that if there are major changes, specifically major cuts that come out of the federal government through the ongoing reconciliation process underway there. We saw a bill pass through the House of Representatives last week, which would, in fact, impose some really significant cuts. There is unofficial willingness on the part of the leaders of the legislature to come on back and to try to make sense of that. The budget, as passed, provides a variety of contingencies that allow for summer maneuvering if the circumstances require it. But the important thing to know is that formally, there are only a few more days of the legislative session. This chart that you see in front of you is purple only through the 12th of June. And according to Andrea Stewart-Cousins, who leads the Senate, I was just at a briefing with her last week. She indicated the calendar is the calendar, and there's no intention to come on back at this point. So if there is any bill activity in the more traditional sense outside of the budget, it's going to happen in this very compressed timeframe that we have left. So we will, at the program, of course, be keeping you apprised if there's legislation that makes its way over the line, as it were, through both the Senate and the Assembly that all of you should know about. Of course, the gubernatorial signature then will have to happen at some point later down the line, but we'll keep you all apprised. That is, for the moment, though, what's happening at the state level, with a lot of eyes on the federal government to see where we go next. So keep that in mind as we move to our next presenter, who is Caroline Westover, as I noted. Caroline is back on the program to discuss this federal court issuance of a nationwide injunction. Caroline, it's an exciting time in the world that you practice in within immigration. Every day is a different one, and looking forward to hearing what has indeed transpired in these last days. The floor is yours.
Thanks, Gabe. I appreciate it. Thanks for including me in today's session. I want to share actually two very brief immigration updates that will hopefully be of interest to our higher education attendees. The first occurred late last week on Thursday, May 22nd. Earlier this year, in late March and April, many of our foreign national students attending higher education institutions here in the U.S. and across the United States were impacted when their legal statuses were terminated in the SEVIS system. SEVIS stands for the Student and Exchange Visitor Information System. They were terminated by the Trump administration, often without any advance notice or notice whatsoever to either the student or the institution. Some foreign national students opted to fight this termination action individually through lawsuits filed in federal court, arguing that the Administrative Procedures Act and the Fifth Amendment due process protections were not followed with these quiet, surreptitious revocations and terminations. Many courts actually offered temporary relief in response to these lawsuits, and often sided with the students and ordered the reinstatement of student statuses. By late April, in one of these actions, the Department of Justice announced in the court action that the federal government would temporarily stop the suspension and the termination of these student statuses and reinstate these students who had been revoked. Specifically, they also announced that ICE would be working on a process to clarify when student status could be terminated. Why is this important? Last week, May 22nd, a federal judge in California issued an injunction to block the Trump administration from terminating the legal status of students, foreign national students, at colleges and universities throughout the entire United States. This court decision also prohibits the federal government from arresting and detaining federal students based on their immigration statuses while their cases were pending in court and going through the judicial process. And equally interesting, it prohibits the federal government from transferring any of the named plaintiffs in these cases or similarly situated plaintiffs from outside the jurisdiction of their residence pending the resolution of these proceedings. As many of us saw on news, a student may be in school in Massachusetts, and then they were moved to facilities in other states far, far away from where they had typically resided. So this is a key update, but here this decision is important because it provides relief to foreign national students on a nationwide basis. Significantly, the California judge that issued this national injunction read and noted at each turn in this and similar litigation across the nation, defendants from the federal government have abruptly changed course to satisfy courts' expressed concerns, and it's unclear how this game of whack-a-mole will end unless defendants are enjoined from skirting their own mandatory regulations. In short, this judge is trying to show that there are processes to be followed. They were not followed in this case. So more about that. Stay tuned. I suspect that there will likely be a government appeal, and so that case will be going. The second brief update I wanted to share also took place last Thursday. Very busy day for immigration matters in higher ed. But certainly on the cusp of the holiday weekend, the U.S. Department of Homeland Security ordered the termination of Harvard University's Student Exchange and Visitor Program. They call that the SEVIS certification. What impact did that move have, or does this have? In short, revocation of an institution's CVIP certification means, in this case for Harvard, that it would no longer be able to enroll foreign international students. That's a very big deal because Harvard has about a quarter, maybe 25 to 27% of its student body is international students. Not being able to enroll them or to maintain their status here would have significant ramifications, not only for those individuals impacted, but certainly for the institution as well. In addition, the revocation of Harvard's CVIP certification also impacts students who had been accepted and had intended to enroll or were planning on enrolling in courses either this summer or this fall. This revocation highlights the existing tension between the Trump administration and education institutions throughout the United States. According to the explanation offered by Department of Homeland Security, Harvard's leadership created a, quote, unsafe campus environment by permitting anti-American, pro-terrorist agitators to harass and physically assault individuals, including many Jewish students, and otherwise obstruct its once venerable learning environment. Many of these agitators are foreign students. That was in a press release from Department of Homeland Security. Thereafter, Department of Homeland Security Secretary Noem stated that it's a privilege for individuals to attend a school and enroll students, foreign national students to U.S. institutions. They said Harvard lost the student and exchange visitor program certification as a result of their failure to adhere with the law, but significantly for any higher education student, an institution in the United States, let this serve as a warning to all universities and academic institutions across the country. So what's really prompting all this? What's prompting this is many believe that the Trump administration is trying to influence campus programming, hiring, admissions decisions, and the like at well-known institutions throughout the United States. After this CVIP certification was revoked, Harvard on Friday, May 23rd, filed a lawsuit in federal district court in Massachusetts. And only a few short hours later, a U.S. district judge granted a temporary restraining order pausing this action against Harvard University. And Harvard had argued that the institution's First Amendment rights were infringed here. So the other key piece to know, students enrolled at Harvard, their status is not jeopardized at the moment, but it is a decision that we're all keeping an eye on. We expect that the parties will resume in that court later this week, and we'll see what other actions may stem from this litigation, but certainly something we're all keeping an eye on because many institutions of higher education are waiting to see what happens to Harvard, likely because they too could be impacted.
Caroline, yes, you are right that there is a lot happening, and thank you for contextualizing, and we will gladly have you back on the program as more is revealed, but really very much appreciate this update. Thank you.
Thanks, Dave.
And let's move to our next presenter. Pardon me, that is Jen Swartzat, who's familiar to many of you. She's been on the program a number of times over and has been tracking an important provision in the budget that relates to education law. Jen is a litigator who also focuses with extensive effort in the education space and is here to tell us all about what this standard that was approved through the budget means for all of you, particularly those in the education space. Jen, the floor is yours.
All right, thanks so much, Gabe. I appreciate the invitation to come back today. Can we go to the first slide, Kathy? Thank you. So whether everybody knows it or not, there is a law in New York that requires all children between the ages of 6 and 16 to go to school. The obligation is on parents to make sure that their children go to school. And in fact, although it's not common, there is a misdemeanor offense for failure to do that. The two choices, of course, you have free public education, but you also have the opportunity to send your children to private school. And should you elect to do that, there is a requirement, as I've set forth here in the New York State education law at 3204, that says, and this part of the law has been existing for decades, that instruction given to a minor elsewhere than a public school, so a non-public school, shall be at least substantially equivalent to the instruction given to minors of like age and attainments at the public schools of the city or district where the minor resides. So that was something that was fairly straightforward for most of New York State public education history. Until relatively recently, there had never been a definition of what substantially equivalent was or what was meant. It was a determination that was just thought to be available for challenge, but typically wasn't. However, in 2022, the New York State Education Department, which is the administrative agency, as many of you likely know, who oversees New York education in the state of New York, promulgated regulations giving a definition to substantial equivalency. And important for what I'm going to talk about here in a moment, setting forth a process for how that determination is made as to whether a non-public school is determined to meet that standard. The process put the onus on local school districts in most all instances, except for certain schools that are covered by what's called the Felder Amendment. Those schools have generally the category that was created for them are typically yeshiva institutions, which are single-sex Jewish schools that focus on a particular curriculum. And then for those schools, the New York State Education Department retained authority to make a determination whether those schools met the substantial equivalency standard. So that they were promulgated in 22, they came into effect in 2023. And they were frankly, it was very contentious among the different, certainly the yeshiva community, as well as local school districts now having another burden on them to do something else. And in this case, not even to benefit their own students, but to benefit students who are attending non-public schools. So Kathy, if you could go to the next slide, please. The budget legislation, there was the Assembly and the Senate worked together and with the governor's office, and they created an additional provision, the 3204, which is subdivision 6. And that, what it did was create statutorily what could constitute as, and we'll get to the details of that on the next slide, but what would constitute as substantially equivalent education. So it did not alter the process that's set forward in those regulations that I just mentioned, but it did take away the exclusive control from the school districts. Okay, I apologize. Kathy told me I must not have sent her all the slides, so I will just go over it because I have it on the list here. So so SED and the local school districts are not the sole determiners of whether substantial equivalency is met under this new legislation. Under the legislation, a non-public school is considered automatically to provide substantially equivalent instruction if it is a certain category, and I'm just going to read the categories as a general matter. If it's a registered high school serving grades 1 through 8 that has if it's a registered elementary school that has a registered high school, a state-approved private special education school, or a state-operated or state-sponsored school, a non-public school that's accredited or received accreditation. There are a number of federal accreditation bodies or many recognized by the Commissioner of Education here in New York. A school that participates in an international baccalaureate program. A school that the instruction is determined by the United States government. That more often happens if there is a school on a Army base, for example, and a school in which a percentage of students score proficient on year-end assessments in the same subject areas that are taken by public school students in the particular region of the state where those schools and in the public schools are located. And if they administer year-end summative assessments and their 3-year average participation rate is similar to the local public schools. So that is a laundry list of things that now substantial equivalent instruction is automatically determined if the school could meet those requirements. It's been reported that the education department is not happy about this, that their ability to control how these determinations are made. As noted here, the legislation does not happen in the event that SED's already determined a school is not substantially equivalent. However, we know that the New York City Department of Education has said to schools, we're putting a pause on doing anything with any schools we've already made that determination or recommendation about until we get further guidance from the state. So certainly the process for what happens in the regulations, if a school had previously been determined to not be substantially equivalent, is on hold. And there is also an indication that this would have to be an annual determination. In other words, is the legislation makes clear that the satisfaction of the criteria in 1 year does not satisfy for future years. So I know that's kind of content rich. If you're not in the education space, that might not be, you might not be as familiar with that. But if you're more interested in it, I certainly, folks here at the firm could provide you information. We also just put out an alert that's available on our website for folks who might want to know a little bit more about that. So I'll pass it back to you, Gabe.
Jen, thank you. Really informative. And there's some questions that came through the chat if you have a minute to check those out. And we hope to have you back on the program if there are updates as this all gets implemented. So let's move to our final speakers for the program today, who are from our Albany office. They are Eric O'Brien and Ryan Cross, and both of them are litigators. We are thrilled to hear from them because they are going to give us some basic important do's and don'ts when it comes to controlling litigation. It's something that unfortunately all of us have to contend with from time to time. It's not something that's necessarily welcome in a business setting per se or otherwise, but knowing how to handle it and being with steady hands is something that we're hopeful all of you can hear more about through Eric and Ryan's eyes and of course what they have to say here. Eric's going to go first and he will then hand off to Ryan momentarily. Eric, welcome back to the program. Glad to have you from Albany, and please go right ahead.
Thank you, Gabe. And thank you everyone for joining us this afternoon. As Gabe mentioned, we're going to take a step back from some recent developments as we've previously discussed, and discuss some best practices with regard to litigation avoidance. Specifically, I'm going to discuss some contractual provisions which should be considered prior to any dispute arising, which can be used to control and potentially avoid litigation. First, a provision that should be considered is a jurisdictional or a venue provision. In a dispute, you don't want to have to litigate whether the court has jurisdiction over the other party. You can contract in an agreement that a specific court or courts in any given state or area within the state will be the exclusive forum for a dispute between the parties. This is an especially important area of concern if one of the parties is from an out-of-state jurisdiction or from a foreign jurisdiction. You can eliminate any concern about where this dispute will be litigated or decided simply through an acknowledgement in the agreement that a chosen court has jurisdiction over the parties and has jurisdiction over the dispute. If you elect to select a jurisdiction that you are in, that can amount to a home court advantage, and it will save you some time and expense from having to litigate to obtain that advantage. Another contractual provision which should be considered is an attorney's fees provision. This is a question that is posed to me often as to whether or not attorney's fees is something that can be obtained through the course of litigation. Unfortunately, the answer to this is often no. However, absent a contractual provision or a statute authorizing an award of attorney's fees, they are generally not recoverable. However, you can include in a contract a attorney's fees provision, and this provision is a chance to flip the American rule, and it can even be unilateral as long as that provision does not violate the doctrine of unconscionability. This type of provision can provide a strong deterrent against to the other side against any frivolous or weak claims or defenses. If a claim isn't the strongest and may not be meritorious, it may result in the other contracting party with taking an additional look or even refraining from asserting that claim if they know that they may have to pay for your attorneys in defending that. This is an extremely important provision, which is within your control when you're contracting with another party. Similarly, a provision which limits the damages available. You can contractually limit damages for breach at the outset of that contract. These are enforceable in New York, except in instances of gross negligence or recklessness. You can agree at the outset to limit liability for consequential damages, incidental damages, punitive damages, delayed damages, or even lost profits. And in certain circumstances, you can specify damages at a certain amount when the harm of a breach is difficult to predict or quantify. This is often referred to as liquidated damages. This helps provide some certainty and some clarity for you as to what the scope of exposure you have in the event of a dispute arising. Similarly, you can include a provision that allows you to seek an alternative method to standard litigation. This is often referred to as alternative dispute resolution, or ADR. You can agree in advance on how to resolve disputes between the parties through this method. You can specify to resolve these disputes through a face-to-face meeting, through a mediation, or you could submit to a binding arbitration. Even with that last option, you can even specify how the ADR will take place and whether or not it'll utilize existing ADR protocols or procedures, and even who will bear the expense of that procedure. Properly drafted arbitration clause can even prevent class action claims in the context of an arbitration. It is important to note, though, that there are limitations on ADR clauses. Sometimes these clauses can be voidable at the option of the other individual. Additionally, if you're considering an ADR provision, it's important to consider the scope of the claims which you wish to be included in that clause, i.e. you're looking to see how broad or narrow that you want the clause to be and how inclusive of claims you want it to be. Similar to our jurisdiction and venue provision, there's also a choice of law provision. This operates in a similar fashion, except instead of a jurisdiction or a venue, you're defining the actual locale's law that will apply to your matter. To ensure the predictability and the certainty of what law is going to be applied, you can specify, as I just mentioned, which state's law will govern in the event of a dispute between the parties. You want to avoid getting into a situation where you get into a dispute with another party, and then you find out that the claims which they have asserted or you're asserting are actually governed by a different state. That can drastically change the outcome of what how those claims will play out. It can change a lot of different things in how the litigation proceeds. New York General Obligations Law, Section 5-1401, can even provide that a choice of law provision in an agreement designating New York law to govern the parties' rights and duties can be valid, even if the agreement has no reasonable relation to this state, provided that the transaction is valued at a minimum of $250,000. However, there are still limitations in a choice of law provision which has no reasonable relation to the agreement at issue or violates public policy, generally will not be enforced. Where there is a reasonable relation to this state, this is a really important provision to consider, as it does provide that predictability and certainty as to what state's laws will be applied in these claims. And the final contractual provision to consider is a statute of limitations provision. You can, in the agreement, limit the time period by which a claim must be asserted against the other arising out of an agreement. Again, this buys you some peace of mind and some certainty as to what time frame a claim can be brought. In New York, a statute of limitations for breach of contract is ordinarily 6 years from the date of breach, so a dispute can arise. After a year, everything settles down and it seems like the dispute's not going to happen and everyone's moved on their way. And then 5 years later, a lawsuit is brought. So something to consider is shortening that period of time, and courts have even upheld provisions providing as little as a 90-day statute of limitations period can be appropriate as long as they are reasonable to be enforced. And regarding some additional pre-suit considerations, I'll pass them along to my colleague, Ryan Cross.
All right, thanks, Eric. I will keep my comments brief because I know we're running short on time and everyone has a busy day. Eric just gave you a lot of really great information about what terms should be or could be included in a contract. What I would just say to put a bow on all of that, engage your attorney early and often. Have them review your contracts, update terms, make sure that they are consistent. The terms are consistent with current law. Especially in the world or the age of AI, it's easy just to go online and generate a contract. But I will tell you, there's having an attorney put eyes on it can save you a lot of money in the long run. So quickly to discuss a topic that everybody wants to avoid, but sometimes it's just part of doing business, litigation, and maybe how we can avoid it. Typically, litigation, you either have an idea that a dispute is coming, you have correspondence or communication with a customer, a client, you kind of know that there's a dispute there. But oftentimes what really triggers it is receiving a demand letter. And that's a formal letter from an attorney saying, this is the dispute, and often there's a monetary amount that's demanded. When you receive those demand letters, similar to milk, do not age well. Get that over to your attorney, whether it's in-house counsel or your attorney at bond, to review so that we can advise you on the appropriate next steps. When you receive that demand letter, it triggers what's called a duty to preserve evidence. And I'll get into more of that here in just a minute. But essentially, you now that litigation is anticipated, you have a duty to preserve evidence that is related to that litigation. So what does that mean? Essentially, any communications, any documents that may be related, if your company has any document retention system or any destruction policies, such as your emails are destroyed every 30 days or every 6 months, you need to speak with your IT department, make sure that you put a hold on all of that. And your attorneys can advise you more on what documents, what communications need to be preserved. But anytime that litigation is anticipated, such as when you receive a demand letter, there is a duty that you must preserve that evidence. So some things that can happen if you don't preserve the evidence. A court can instruct a jury. It's called an adverse jury instruction. Basically, if you don't preserve evidence or if you intentionally destroy evidence, they can instruct the jury to basically that they can instruct the jury that the evidence was destroyed because it would have been unfavorable to you. And so they can instruct the jury to infer that information or that document or evidence goes against or goes in favor of the plaintiff's claim or against your defense or counterclaim. They can also, there's monetary sanctions, and even in some really egregious situations, they can even strike claims such as defenses or counterclaims. So just to wrap all of this up, I would say engage your attorney early and often, have them review your contracts, have them, if you receive a demand letter or you think that a dispute is coming, pick up the phone, call your attorney, and we can advise you on how to proceed. Thank you.
Ryan, thank you. Eric, thank you. Really appreciate those tips. And I know that the litigation team is going to be coming back throughout the summer with more such practical knowledge for all of you. So thank you for the first of what will be a few presentations on this area of the law. And if we can go to the next slide, Kathy, I appreciate it very much. Here you'll find the email addresses for all of today's presenters. If you have questions, feel free to reach out to any of them as well as to me. And next presentation will be a week from today, and we'll cross into June. You'll be with my co-host, Carrie Langen, and then I will be back with you as we move closer to mid-June. In the meanwhile, really thank you all for your continuing loyalty to the program, and we'll be with you in a week's time.